The Texas Penal Code doesn't contain any offense with the word rape included in the title. Almost all offenses we would commonly refer to as rape fall under the statutes of sexual assault and aggravated sexual assault. We'll first discuss sexual assault. Rape, or sexual assault as termed in the Penal Code, is second only to homicide in terms of seriousness in our society. The Penal Code offense of sexual assault must include, at the minimum, some sort of non-consensual penetration or non-consensual contact between specific body parts. Sexual assault doesn't necessarily have to include violent acts or deadly weapons. Those fall under the aggravated sexual assault statute. There are two different sets of elements of the offense within the sexual assault statute. First, the Penal Code states a person commits this offense when he or she intentionally or knowingly and without consent causes the penetration of the anus or sexual organ of another person by any means, causes the penetration of the mouth of another person by the sexual organ of the actor, or causes the sexual organ of another person to contact or penetrate the mouth, anus, or sexual organ of another person, including the actor. Keep in mind the body part types being described by the Penal Code, and also realize that non-consensual doesn't necessarily mean by use of physical force. In fact, the Penal Code considers several circumstances to automatically mean the sex acts we just described occurred without consent. These acts are non-consensual if the actor uses physical force, violence, or coercion, the actor threatens physical force or violence against the victim or another, and the victim believes the actor is capable of making good on the threat, the victim is unconscious and the actor knows he or she has not consented, the victim has a mental disease or defect and is not able to consent and the actor knows it, the victim is unaware the sexual assault is occurring or has not consented and the actor knows it, the actor knows that the other person is intoxicated or impaired by any substance to the extent that the other person is incapable of consenting. The actor is a public servant who coerces the victim to submit or participate. The actor is a mental health or a healthcare services provider who exploits the emotional dependency of a patient or former patient. The actor is a clergyman who exploits the other person's emotional dependency while serving as their spiritual advisor. The actor is an employee of a facility where the victim is a resident. The actor is a healthcare services provider who uses his own semen or the semen of another to fertilize an egg of a woman without her consent, otherwise known as fertility fraud. The actor is a coach or tutor who causes the other person to submit or participate by using the actor's power or influence to exploit the other person's dependency on the actor. Or the actor is a caregiver hired to assist the other person with the activities of daily life, for example, a home health care worker, and causes the other person to submit or participate by exploiting the other person's dependency on the actor. Remember, all of the preceding circumstances make sexual acts considered to be non-consensual and therefore sexual assault. The second set of elements of the offense are what would be commonly referred to as statutory rape, though Texas doesn't use those words. Keep in mind, all of these elements define a child as a person younger than 17. The Penal Code states an actor commits sexual assault if he or she intentionally or knowingly causes the penetration of the anus or sexual organ of a child by any means, penetration of the mouth of a child by the sexual organ of the actor, the sex organ of the child to contact or penetrate the mouth, anus, or sex organ of another including the actor, the anus of a child to contact the mouth, anus, or sex organ of another including the actor, or the anus of a child to contact the anus or sexual organ of another including the actor. Remember, all these acts must involve penetration or contact in certain body parts. What we commonly know as molestation or fondling would probably not be the offense of sexual assault as long as there's no penetration. It's probably going to be the offense of indecency with a child. The statute states this second set of elements of the offense are committed regardless of whether the actor knew the age of the victim at the time of the offense. This means the mistake of fact defense, or essentially a defendant arguing, I didn't know the child wasn't 17, or I thought the child was 17, may not be used. The offense is committed regardless of the defendant's knowledge of age. There are several defenses to prosecution to sexual assault of a child. The first is if the contact consisted of recognized medical care. The next includes what is commonly referred to as a Romeo and Juliet defense. The Penal Code states it is an affirmative defense to sexual assault of a child if the persons were married, as long as the relationship was not incestuous or illegal under the Penal Code offense of prohibited sexual conduct, which addresses sexual contact within an extended family, such as between aunts and uncles, cousins, nieces, and nephews, etc., or there was 3 years or less age difference between the persons and the actor was not a registered sex offender, had no previous convictions, the victim was 14 or older, and the relationship was not incestuous or illegal under the Penal Code offense of prohibited sexual conduct. Fertility fraud, in which the actor is a healthcare services provider who uses his own semen or the semen of another to fertilize an egg of a woman without her consent, is a state jail felony. Sexual assault occurring in an incestuous manner or that is illegal under the Penal Code offense of prohibited sexual conduct is a felony of the first degree. All other offenses of sexual assault are felonies of the second degree.